is my one of the part of the Constitution series, Territory of the Union. As has been already stated, the political structure prescribed by the Constitution is a federal union. The name of the union is India or Bharat, Article 1 of 1. And the members of this union at present are 28 states of Andhra Pradesh, Assam, Bihar, Gujarat, Haryana, Karnataka, Kerala, Madhya Pradesh, Tamil Nadu, Maharashtra, Nagaland, Odisha, Punjab, Rajasthan, Uttar Pradesh, West Bengal, Jammu and Kashmir, Himachal Pradesh, Manipur, Tripura, Meghalaya, Sikkim, Mizoram, Arunachal Pradesh, Goa, Chhattisgarh, Uttaranchal and Jharkhand. Barring Jammu and Kashmir, which has still a special position under the Constitution, the provision of Constitution relating to the states are now applied to all these states on the same footing. Now for the present, Jammu Kashmir has got no special status under Article 370 of our Constitution. The expression Union of India should be distinguished from the expression Territory of India. While the Union includes only the states which enjoy the status of being members of federal system and share a distribution of powers with the Union, the Territory of India includes the entire territory over which the sovereignty of India for the time being extends. Thus, besides the states, there are two other classes of territories which are included in the Territory of India. Union territories, दूसरा, such other territories as may be acquired by India. The Union territories are since 1987 7 in number: Delhi, Andaman, Nicobar Island, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, Pondicherry and Chandigarh. But as far as Delhi is concerned, this has got its limited power of state. For the Union Territory of Pondicherry, the Parliament has, by enacting a law, viz. Pondicherry Administration Act 1962 under Article 239A, made the provision for a legislature, etc. By an amendment of the Constitution, two new articles, viz. 239AA and 239AB, were inserted in 1992, providing for a legislature and a ministry for Delhi, which has been named as National Capital Territory of Delhi by Article 239AA. Rest of the Union territories are centrally administered areas to be governed by the President, acting through an administrator appointed by him and issuing regulations for their good government. Any territories which may at any time be acquired by India by purchase, treaty, cession and conquest will obviously form part of the Territory of India. These will be administered by the Government of India subject to legislation by Parliament. Article 246, Sub-Article 4. Thus, the French settlement of Pondicherry, together with Karaikal, Mahe and Yanam, which was ceded to India by the French government in 1954, was being administered as an acquired territory until 1962. Inasmuch as the Treaty of Cession has not yet been ratified by the French Parliament, after such ratification, the territory of these French settlements was constituted a union territory in December 1962. The constitutional developments in Sikkim by way of its integration under the Constitution of India are dramatic. During British days, Sikkim was an Indian state under the hereditary monarch called Chogyal. subject to British paramountcy. Its external frontier in the Himalayas was demarcated by agreement with China in 1890. The Chogyal was a member of the Chamber of Princes. When India became independent, there was a section of public opinion in Sikkim for merger with India. But the princely rule of that state and its strategic position stood in the way. Hence, after the lapse of paramountcy, a treaty was entered into between Sikkim and the government of India, by which a latter undertook the responsibility with regard to the defense, external affairs and communications of Sikkim. Government of India was represented in Sikkim by the political officer who was also assigned to Bhutan. Sikkim thus became a protectorate of the Union of India. In May 1974, the Sikkimese Congress decided to put an end to monarchical rule, and the Sikkim Assembly passed the Government of Sikkim Act 1974 for the progressive realization of a fully responsible government in Sikkim and for furthering its relationship with India. This act empowered the government of Sikkim to seek participation and representation of the people of Sikkim in the political institutions of India for the speedy development of Sikkim in social, economic and political fields. The Chogyal was made to give his assent to the government to Sikkim Bill, under which effective power went into the hands of the representative Sikkim Assembly, and the Chogyal was turned into a normal constitutional head. The Sikkim Assembly, by virtue of its power under the Government of Sikkim Act, passed a resolution expressing its desire to be associated with the political and economic institutions of India and for seeking representation for the people of Sikkim in India's parliamentary system. The Constitution 35th Amendment Act 1974 was promptly passed to give effect to this resolution. The main provision of this amendment act were Sikkim will not be a part of the territory of India but an associate state, which was brought within the framework of Indian Constitution by inserting Article 2A and 10th schedule in the Constitution, which were subsequently omitted by the Constitution 36th Amendment Act 1975. Sikkim would be entitled to send two representatives to the two houses whose rights and privileges would be the same as those of other members of parliament, except that the representatives of Sikkim would not be entitled to vote at the election of the President or Vice President of India. They would also be subject to the disqualification for members of parliament under the Indian Constitution. The defense, communications, external affairs and social welfare of Sikkim would be a responsibility of the Government of India, and the people of Sikkim would have the right of admission to institutions for higher education, to all India services and the political institutions in India. The Government of Sikkim shall retain residual power on all matters not provided for in 10th schedule to the Constitution of India. There is a little doubt that the 35th Amendment Act 1974 introduced innovations into the original scheme of the Constitution of India. There was no room for any associate state under the Constitution of 1949. India was a federal union of states under territories and acquired territories. Article 1, Sub-Article 3. Of course, Article 2 empowered the Parliament of India to admit new states into the Union, but the Constitution 35th Amendment Act did not seek to admit Sikkim as a new state of the Indian Union. It was to be territory associated with India and would have representatives in the Indian Parliament without being a part of the territory of India. The criticism of the introduction of the status of an associate state into the federal system has, however, lost all practical significance because Sikkim has shortly thereafter been admitted into the Indian Union as the 22nd state in the first schedule of the Constitution of India. We shall now advert to this later development. While the Indian Parliament was enacting the Constitution 35th Amendment Act, the Chogyal resented and sought to invoke international intervention. This provoked the progressive sections of the people of Sikkim and led to a resolution being passed by the Sikkim Assembly on April 10, 1975, declaring that the activities of the Chogyal were prejudicial to the democratic aspirations of the people of Sikkim and ran counter to the agreement of May 1974 executed by Chogyal. The Assembly further declared and resolved that the institution of the Chogyal is hereby abolished and Sikkim shall henceforth be a constituent unit of India, enjoying a democratic and fully responsible government. The resolution of the Assembly was submitted to the people of Sikkim for their approval. At the referendum so held, there was an overwhelming majority, and the Chief Minister of Sikkim, on behalf of his Council of Ministers, urged the Government of India to implement the result of the referendum. This led to the passing by Indian Parliament of the Constitution 36th Amendment Act 1975, which was later ratified by the requisite number of states under the Article 368(2) proviso. By the 36th Amendment Act, Sikkim has been admitted into the Union of India as a state by amending the first and the fourth schedule, Article 80, 81, and omitting Article 2A and the 10th schedule with retrospective effect from 26/4/1975. Article 371F has further been inserted to make some special provisions relating to the administration of Sikkim. It has already been pointed out that the Indian Federation differs from the traditional federal system insofar as it empowers Parliament to alter the territory or integrity of its units, namely the states, without their consent or concurrence, where the federal system is the result of a compact or agreement between independent states. It is obvious that the agreement cannot be altered without the consent of the parties to it. This is why the American Federation has been described as an indestructible union of indestructible states. It is not possible for the national government to withdraw the map of the United States by forming new states or by altering boundaries of the states as they existed at the time of the compact without the consent of the legislatures of the states concerned. But since federation in India was not the result of any compact between independent states, there was no particular urge to maintain the initial organization of the states as outlined in the Constitution, even though interests of the nation as a whole demanded a change in this respect. The makers of our Constitution therefore empowered Parliament to reorganize the states by a simple procedure, the essence of which is that the affected states or states may express their views but cannot resist the will of Parliament. The reason why such liberal power was given to the national government to reorganize the states is that the grouping of the provinces under the Government of India Act was based on historical and political reasons rather than the social, cultural, linguistic division of the people themselves. The question of reorganizing the units according to natural alignments was indeed raised at the time of making the Constitution, but then there was not enough time to undertake this huge task considering the magnitude magnitude of the problem. The provision relating to the above subjects are contained in Article 3(4) of the Constitution. Article 3 says, Parliament may by law form a new state by separation of territory from state, or by uniting two or more states or parts of states by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, or unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states. The bill has been referred by the President to the legislature of that state for expressing their views thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed has expired. Article 4 provides that any such law may make supplemental, incidental, and consequential provision for making itself effective, and may amend the first and fourth schedule of the Constitution without going through the special formality of the law for the amendment of the Constitution as prescribed by Article 368. These articles thus demonstrate the flexibility of our Constitution by a simple majority, and by the ordinary legislative process Parliament may form in new states or alter the boundaries etc. of existing states, and thereby change the political map of India. The only conditions laid down for the making of such a law are no bill for the purpose can be introduced except on the recommendation of the President. The President shall, before giving his recommendation, refer the bill to the legislature of the state which is going to be affected by the changes proposed in the bill, for expressing its views on the changes within the period specified by the President. The President is not, however, bound by the views of the state legislature so ascertained. Here is thus a special feature of the Indian Federation, which that territories of the units of the Federation may be altered or redistributed if the Union Executive and Legislature so desire. Since the commencement of the Constitution, the foregoing power has been used by the Parliament to enact the following acts. The Assam Alteration of Boundaries Act 1951 altered the boundaries of Assam by ceding a strip of territory from India to Bhutan. The Andhra State Act 1953 formed a new state named Andhra by taking out some territory from the state of Madras as it existed at the commencement of the Constitution. The Himachal Pradesh and Bilaspur New State Act 1954 merged the two Part C states of Himachal Pradesh and Bilaspur to form one state, namely Himachal Pradesh. The Bihar and West Bengal Transfer of Territories Act 1956 transferred certain territories from Bihar to West Bengal. The State Reorganization Act 1956 reorganized the boundaries of the different states of India in order to meet local and linguistic demands, apart from transferring certain territories at between the existing states. It formed the new state of Kerala and merged the former state of Madhya Pradesh, Madhya Bharat, Pepsu, Saurashtra, Travancore, Cochin, Ajmer, Bhopal, Kutch, and Vindhya Pradesh in other adjoining states. The Rajasthan and Madhya Pradesh Transfer of Territories Act 1959 transferred certain territories from the state of Rajasthan to that of Madhya Pradesh. The Andhra Pradesh and Madras Alteration of Boundaries Act 1959 made alteration in the boundaries of the states of Andhra Pradesh and Madras. The Bombay Reorganization Act 1960 partitioned the state of Bombay to form a new state of Gujarat, and the name of the residue of the Bombay as Maharashtra. Thus, the state of Bombay was split up into two states, Maharashtra and Gujarat. The Acquired Territories Merger Act 1960 provided for the merger into the state of Assam, Punjab and West Bengal of certain territories required by agreements between the government of India and Pakistan in 1958 and 1959. A similar transfer of certain territories from West Bengal and Assam to Pakistan under the aforesaid agreement was provided for by enacting the Constitution 9th Amendment Act 1960, because the Supreme Court opined that no territory can be ceded from India to a foreign country without amending the Constitution. The State of Nagaland Act 1962 formed a new state of Nagaland with effect from 1/2/1964, comprising the territory of Naga Hills, Senang area, which was previously a tribal area in the 6th schedule of the Constitution, forming part of the state of Assam. The next change was introduced by the Punjab Reorganization Act 1966, by which the state of Punjab was split up into state of Punjab and Haryana and the Union Territory of Chandigarh with effect from 1/1/1966. The Andhra Pradesh and Mysore Transfer of Territory Act 1968, the Bihar and Uttar Pradesh Alteration of Boundaries Act 1968, the Assam Reorganization Meghalaya Act 1969 created an autonomous sub-state named Meghalaya within the state of Assam. Himachal Pradesh was upgraded from the status of Union Territory to that of the state by the State of Himachal Pradesh Act 1970. The Northeastern Areas Reorganization Act 1971 similarly brought up Manipur, Tripura, Meghalaya into the category of states and added Mizoram and Arunachal Pradesh to the list of union territories. The Haryana and Uttar Pradesh Alteration of Boundaries Act 1979, Mizoram, which has been made a union territory by the Act of 1971, was elevated to the status of state by the State Mizoram Act 1986. Arunachal Pradesh, a union territory, was made a state by State of Arunachal Pradesh Act 1986. Goa became the state by virtue of Goa Daman and Diu Reorganization Act 1987, separating it from Daman and Diu with effect from 30/5/1987. A new state of Chhattisgarh was created by carving out its territory from that of the territories of Madhya Pradesh by enacting the Madhya Pradesh Reorganization Act 2000 with effect from 1/11/2000. The state of Uttaranchal came into being on 9/11/2000 by separating its territory out of the territories of Uttar Pradesh by the Uttar Pradesh Reorganization Act 2000. By enacting the Bihar Reorganization Act 2000, the state of Jharkhand was created on 15/11/2000 by carving its territory out of the territories of the state. This is all about territory of the unions. Thanks, regards.